And good evening. Today is September the 3rd. Right now it is 7:35, and I'm calling to order this evening's meeting of the Guilford Planning and Zoning Commission. For the benefit of those who have not participated in a Planning and Zoning Commission meeting, our procedures are as follows. The Secretary will read the legal notice of the meeting as published in local newspapers. The applicant will be invited to come forward and present the case, explaining to the Commission and others present what is being requested of this property. Comments of town agencies will be read for each application if there are any. First, there will be clarifying questions from the commissioners. Then there will be an opportunity for clarifying questions from the audience. Next, we'll ask those who want to support the application to come forward and speak. And second, we'll ask those opposing the application to come forward. As this is a public hearing and must be recorded, it will be necessary for speakers to identify themselves by stating their name and address before addressing the commission. The applicant will then be free to leave or remain for the balance of the public hearing and the regular meeting, during which the commission will try to reach a decision on each application. Each applicant will be notified in writing as to the decision of the commission and has the right to appeal to Superior Court if desired. Decisions of this meeting are available the day after the meeting by calling the Planning and Zoning Office at 203-453-8039 after 9 a.m. Seated tonight are the following members of the Guilford Planning and Zoning Commission. We have Walter Corbiere, I'm Rich Meyer, Tom Cost, Josh Hirschman, Frank DeAndrea, who's looking very dapper tonight, and there's Josh Hirschman, and Phil Johnson is joining the team tonight. Phil's an alternate member. Oh, I forgot Richard Wallace. Richard Wallace is here too. Yeah, over here. George Krell, Reggie Reed, Katie Arbuckle, and Shannon is doing the taping for us tonight. Mr. Secretary, please read.
Legal notice, Guilford Planning and Zoning Commission. Notice is hereby given that the Guilford Planning and Zoning Commission will hold a public hearing on September 3rd, 2014 at 7:30 p.m. at the Nathaniel B. Green Community Center, Monunketuck Room, 2nd floor, 32 Church Street, Guilford, Connecticut, for the following purposes. Number 1, Hersher Karen Rose, 4 Chelman Lane, map 38, 14, zone R3, special permit for accessory apartment in a single-family dwelling, section 273-19. Number 2, Guilford Agricultural Society, 111 Lovers Lane, map 40, lot 138, zone R3, temporary modification to special permit, condition of approval number 8, approved September 4, 2013, Article 10. Copies of these applications are available for inspection in the office of the Planning and Zoning Commission, Town Hall South, 50 Boston Street, Guilford, Connecticut. At this hearing, persons may attend and be heard, and written communications will be received. Dated at Guilford, Connecticut, this 14th day of August, 2014. Richard Meyer, Chairman.
Wonderful. Thank you, Mr. Secretary. First, I want to thank everyone for showing up tonight. It's nice to see so many faces. It's important that we all participate in our government, and it's really nice to have so many people present. So thank you so much for coming. First up, we have the Guilford Agricultural Society. Attorney Cronin, you're here to speak.
Thank you, Mr. Chairman. For the record, I'm Attorney Tom Cronin, and I'm appearing.
If anyone's here for the Hersher application, the applicant has requested that you continue that hearing to October 1st, so they don't really need to hang around if they don't want to, if they're here for that purpose.
Okay, so if anyone's here for the Hersher application, it's not going to be tonight, but you're certainly welcome to stay. These are very enjoyable.
Should we take that in order and just move to table it?
No, we can't revise it.
It's okay, just as long as they know. That's fine. Counselor?
Thank you again, Mr. Chairman. I'll start over. Again, for the record, Attorney Tom Cronin, 20 Water Street here in Guilford, and I'm appearing tonight on behalf of my client, the Guilford Agricultural Society, and a few of the members of the society are in the back corner of the room in case there are any questions. The application tonight is a fairly straightforward one. It's also a bit of an emergency one. The gist of the application is set forth in the letter that I sent, the transmittal letter with the application. For those of you who don't have it or haven't seen it, it requests and I have to be formal about this, a modification of a temporary modification of a condition in the original special acceptance permit, which goes back to 1989, which was modified in September of 2013. At the time of the September 2013 modification, the application in front of this commission was for the approval of 2 structures. I wasn't the counsel of record at the time, but my recollection and my reading of the record tells me that there were 2 structures one of which was approved permanently for storage, and the other of which was more for, I think I'll call it the pavilion, was more for transient use. This commission put a condition on the approval of that building that basically said it could be used for events that were booked as of that date through the end of 2013. So the use of that building in 2014 has not been permitted. Now, having gotten that far, I'm going to go out on a limb and talk about the elephant in the room, because my client is perhaps a bit at risk of being persona non grata tonight because of stuff that happened. And I think it's responsible for me to put on the record what happened, and I'm going to take the hit for part of it, and I'll do so as apologetically unapologetic as I can be. The condition that was put on in September of 2013 was basically put on after a discussion. Mr. Kroll participated, Mr. Bauer participated, I don't remember who else from the commission participated, but there was a fairly substantial outcry from the neighborhood about the application. I won't comment on the merits, but the decision was that the Ag Society was supposed to go meet with the neighbors, try to find a mutually acceptable set of conditions that everybody could live with, and the idea would be that the Ag Society would come back with a, I'll call it a permanent special exception application that included some conditions that might make things in the neighborhood work better. For reasons that I can't fully explain and that I don't take responsibility for, those meetings didn't take place during the end of 2013. That didn't happen. Shame on us because it didn't happen. We got into 2014 and the Renaissance Fair, which was an event that by many interpretations of the existing special exception, unmodified, probably should not have been. It happened for a number of years, but it was operated at the time as a for-profit operation, and the 1989 special exception didn't allow for-profit operations. My clients came to me and said, what do we do? And they were between a rock and a hard place, and they may have appeared defiant in going forward with that. If they did, I need to tell you they did so on my express opinion. They had a contractual obligation to go forward and do something that they were not permitted to do, and those of you who are lawyers, those of you who have worked with lawyers may know sometimes the advice a lawyer gives isn't the best advice, it's the least bad advice. So I instructed them, or I counseled them that in my opinion, they should go ahead, avoid the contractual liability with the full understanding that they were in violation, they would face a cease and desist order, and my job was to enable that event to go forward as best it can. So if somebody is to blame for that black eye, it's me and it's not the Ag Society. Now, subsequent to that, we have had at least 3, and I want to say 4 meetings with a subgroup of neighbors. And I would say that those discussions have been cordial, they've been candid, they have not yet borne fruit. I understand that the First Selectman's Office has gotten involved, and there have been a couple of meetings that are probably likely to be more productive because lawyers aren't present. So there is an effort underway to try to bridge the gap. I would be lying to you if I didn't tell you that it is very, very hard to address the myriad concerns from a whole bunch of neighbors. An interesting little anecdote was during the Renaissance Fair, one of the things we did do was the Ag Society, eliminated the jousting event because that was kind of, in their opinion, noisy and provocative and so on. And some of the neighbors who weren't in favor of the special permit were disappointed that that event had been discontinued for that event. We have people who like fireworks and people who don't like fireworks. We have people who like Oompa bands at the Oktoberfest and people who don't. And so far, the task has proven beyond my ability to try to bring everything together in a way that satisfies everybody. So when we come back, I'm not sure we're going to satisfy everybody, but I am sure we're going to come back with a clean slate saying we tried very, very hard, and here's how far we got. Now, that trip back to you, I didn't want to come back prematurely because I translated the message from the September 2013 decision as one saying, don't make our job tougher. Go talk to the neighbors, figure this out, come back with something that everybody can live with. I've taken that task, if I understood it correctly, seriously. We're not at a place tonight where we have that. We have the fair coming up in a matter of days or weeks. We do not have permission to use that building. Oh, and I should say this. After the Renaissance Fair, I think the next event was the Lobster Fest. Was it the Rotary? I think it's the Rotary Club that does Lobster Fest. They were not allowed to use the pavilion, and to the best of my knowledge, we have been in full compliance since the Renaissance Fair. And just to go back again, if there's someone to take the hit for the Defiant Act on the Renaissance Fair, that was my counsel. And I'm a big boy. If you're upset with me, I would take that. It was the best advice I could give my client under the circumstances. So what we're asking for tonight is to get essentially a dispensation or an indulgence that will allow the fair to go forward. Because as I understand it, because of the location and size of the pavilion, if we cannot use that, the fair itself is in jeopardy. Other events, we're able to put up tents, but in this particular case, because of the size and location of the building, and I guess, Gil, I guess I'd just ask you very briefly, am I going off base here? The size and location of that structure?
The size of the tent can go nowhere else, there's no room.
So we don't have the option of doing what we did with the Lobster Fest, which was put up a tent and cover the waterfront that way. That's the extent of this. We had talked in our last meeting with the neighbors, which I think was as recent, a week ago Friday, I think it was a week ago Friday. We had talked about the possibility of getting a broader, or coming to you for a broader reprieve period. As we worked out the details, we weren't able to come to acceptable terms to do that. So that's more time than I intended to take. That's the background. I just ask that you consider the request, that if you are or were offended by what happened with the Renaissance Fair, you understand that that was not a defiant act by my client. Questions?
Have you counseled your clients not to incur further contractual liability
Yes.
by recontracting with the Robin Hood Fair vendors at this point without a permit?
They will not do. The only event that they cannot have, that they are unable to have right now, is the fair. They just can't have it unless they can use the pavilion.
Wait,
But-
the Robin Hood Fair or
No, the Guilford Fair. The Guilford Fair coming up this month. Okay? All other events going forward need to comply with the regulation, and they have not, again, Gil, no contracts have been signed, no contracts, and Gil is in the back shaking his head, no contracts have been signed that would create the problem that the Robin Hood Fair created the last time. The Robin Hood Fair last time, the problem was not related to what you did or didn't do with the pavilion. It related to the for-profit status of the Robin Hood Fair, or the Renaissance Fair. So, in some sense, that is an event that, in hindsight, when you read the regulation, I won't say carefully, just read it, that is an event because it involved a for-profit operation that was probably never permitted. It was never permitted. But in fact, it had been held, and the loosey-goosey way that my client operates, it's just the truth. I mean, they're not a well-organized corporate machine, okay? And I apologize to the town of Guilford for saying that publicly, but You know, they're a bunch of volunteers, and, you know, we've always done it that way, and if we've always done it that way, we did it again. But that will not replicate itself.
So the Robin Hood Fair is not currently scheduled for May 23rd through June 7th of 2015?
I
I do not have any contracts whatsoever.
For
So,
the record, that was Mr. Lombard in the back.
so what's the, so when people are planning for the May 23rd through June 7th Robin Hood's Fair, they're, where they're getting that information?
I don't know what people are planning on that. I guess I'd say
Is there anything scheduled online, Mr. Lombard, about
Not
that
for us.
time frame?
I can't speak for anyone else.
So it's just
But
not,
I have no contracts whatsoever.
thank you.
I have plenty waiting,
And they're waiting for those dates?
no, they're waiting for contracts. The Lobster Fest, the car show, different races. I haven't booked anything.
Were there fines assessed?
That is correct, there
And
were.
were they
And the Fair
collected?
Association paid every fine.
So, my question is this, when this all started, it was, part of what happened is that the building was put up without a permit.
That's correct.
So, one of my issues would be is,
Without a building permit,
Right.
without site plan.
okay, so has the building been looked at by the building inspector? If the fair is going to use the building, has the building been looked at by the building inspector to make sure the building is safe enough to have
Yes.
occupants in
Yes,
the
because
building?
once you all approved it for the remainder of the events that were scheduled and contracted for last year, then the building official went out and inspected the building.
Okay.
So right now, you're just looking for some time to figure, you're still working with the neighbors,
Yes,
and you're looking for basically time to resolve this issue with the neighbors.
well, I could be a little more narrow than
I
that.
hear.
What I would have loved to have gotten was the ability to come here and say that the neighbors we've talked to have said, look, we're making a good faith effort, we're okay with events through such and such a date. We weren't able to get that. So all I'm asking for is, I wouldn't say time, but only enough time to run the fair, set up the fair, run the fair, and take the fair down.
What does that do to prevent this coming up in the future again?
Well, if they don't do something, it'll come up again next year when they want to have the fair again.
I suppose that's the case. I suppose that's, actually, unless I get fired as counsel because of my comments tonight, I'm going to be back in front of you probably in January with an application, kind of no matter what, because this has to have some finality. I have a legal theory that I'm not prepared to share, but I have a legal theory that would allow me to put a responsible application in front of you and let you vote it up or down. But we are doing everything we can to try to resolve as many open issues as we can. I mean, the issues are like numbers of events, numbers of categories of events, the amount of noise at any event, the amount of traffic at any event, the hours of events. And when you look at the range of events that take place, everything from the fair to the fireworks and car shows and races in between, there's no one size that fits all. And I'm not even finding that there's any 5 sizes that fits all. And that's the problem we've had.
Frank?
Other questions?
Straightforward.
You plan to stop all events after the fair, and you would include that as a condition until this is resolved and put before us?
No. What we cannot do is we cannot use the pavilion.
That's the current situation.
That is the current, I mean, that's the current state of the law. We cannot use the pavilion. If we could figure out a way to do the fair without using the pavilion, I wouldn't have to be here tonight. We are in full compliance with your order as long as we don't use the building that I'm calling the pavilion. That's why the Lobster Fest was a legal event, an event that fell within the framework of your decision.
So there are really a couple things going on. One is that there's a structure which has no approval. And also there was this past situation where a for-profit entity was using the facility. So there's really two. And I know you can't answer this, but while we were wrestling with this last go-around, I remember thinking to myself that they're probably governed by some sort of committee or a group of people. And at some point they had to sit down and say, well, you know, let's sign a contract with a for-profit institution like the Robin Hood thing, knowing that that wasn't an approved use. And I guess we can't go back and undo that. But that is one of the things that are on the table. Do we have any other questions? Phil? No? Rich? Okay, all right.
What are the dates of the fair as they stand?
Gil, what are the dates?
19th, 20th, 21st.
19th, 20th, 21st, but the setup would begin when?
Days before.
Yep.
Yesterday.
That's important that I tell you that because I don't want you to think it's 3 days and see activity down there,
Right.
you know, tomorrow or the next day and wonder what I'm doing. So the setup, if this were approved tonight, you're liable to see activity down there connected to this as soon as tomorrow.
Seems to
And
me.
so at this point, the negotiations are stalled, but while they're stalled, what other events are currently planned?
There's two things that are coming up. They're both school races. I think one's the middle school and I think one's the high school. One's in October and the other one's the end of November. That's the only thing that's left for this year. And
None of which will involve the pavilion,
Right.
and therefore all of which would be permissible.
Okay.
Thank you very much.
Thank you, sir. All right. Do we have any questions or comments? Questions? Comments for, comments against? No? All right.
No thanks here.
We're-
Move this portion of the public hearing be closed.
Second.
Wait, no, we can't do that yet. Because I can't see this, but you can.
We have to read a letter. We have a letter from, I think, a neighbor. It's addressed to George Crawl, and it's in regard to an application for modification of conditions of approval established in the agricultural and approval for application for modification of the special permit dated September 4, 2013, Guilford Agricultural Society, 111 Lovers Lane. Dear Mr. Crawl, as a resident of 12 Paddock Lane, Rollwood Condo Association, Guilford, Connecticut, I'd like to state my objections to the changing the permit referenced above. Thank you for your attention to this matter. Signed, Mildred Parisi, 12 Paddock Lane, Guilford.
All right, so someone is against it. All right, thank you. Do we have any other letters? Anything I'm forgetting? No? We're all set. All right, so let's close this portion of the public hearing and move on to number 2, amend Section 273-2, Table 5, and add 273-22F, adult entertainment facilities. All right, George, guide me.
I'll pick this up. You recall at the last meeting where this topic was introduced at public hearing, you asked that the text of this proposed amendment be sent to Chuck Andrus, our legal counsel, and it was. Chuck Andrus reviewed the proposed text and offered a number of comments. We forwarded those comments to you today. Today's the first day I've looked at them as I was on vacation last week. So I haven't had a full opportunity to go over these things. I think to me, the gist of what he's saying is that we're on the right track in terms of developing this regulation. However, there are a number of suggested changes that he would propose, which are outlined in this document. My recommendation to you is that we continue the public hearing so that I can work with Chuck to incorporate these changes into a final text, which would then be considered at the next meeting. You're certainly free to go over all these tonight if you want to.
Well, I suspect a lot of folks are here to hear about this.
Okay. Unfortunately, it's a lengthy document. We could try to summarize what he's saying.
Could we try to summarize and also put in the framework of what we have and where we're heading with it, just so that they're up to speed?
Sure.
Because we're really kind of doing this for everybody here.
I'm not sure I can do full justice to all of his comments, but I'd be happy to go over that. And also, of course, anyone who wants a copy of this, tomorrow or whenever, we can make that available to them. Just to set the framework again, the proposed amendment allows adult-oriented facilities in the TS and TS2 zones and the I1 and the I2 zones. Would be a permitted use in those zones, subject to a number of other criteria, the most significant of which is the prohibition of any use being established within 1,000 feet of any residential use or any residential zone area, zone line. I reviewed for you last time the effect of that 1,000-foot separating distance requirement. There were 2 and possibly 3, and the third one is close. There are 2 and possibly 3 locations where such facilities could be located. All of them are in industrial zones. None of them are in the TS or TS2 zones, given the 1,000-foot separating distance requirement. And the proposed regulation also has a number of other conditions under which these facilities would be allowed. I think they're all addressed here by Chuck in his memo, so I'll go over that, and that will further enlighten us on what those issues are. As Chuck says in his first comment, this is a significantly improved version. He can't say with any certainty whether having, practically speaking, only 2 or 3 sites available in town if that's sufficient to meet the constitutional tests related to these types of facilities. As you know, because of the First Amendment of the Constitution of the United States, we can't prohibit these types of activities. We have to allow some reasonableness, some reasonable options for them to be created, and whether or not our 1,000-foot separating distance requirement meets that test or not is a judgment call.
So can I jump in while you're talking while the stuff is fresh in my mind? So yeah. I guess what I want to avoid is, there are certain areas way far away from people's houses, and if we say TS2 and reduce it to 600 feet or 500 feet, all of a sudden new areas are going to open up, which are really in a residential setting. And I really want to, the thrust of this for me is to not have it in someone's front yard or backyard. Yes. And so, if we need to reduce that 1,000-foot number, if we need to do that to comply with the First Amendment tests, then I kind of hope that we'll take out the possibility of there being anything in the TS2 zone that might put it in a residential area. I think the industrial area in a lot of towns might work great for them. Mm-hmm. Unfortunately for us, it's so far out of the way that I don't know that it would be viable for a business to survive in a way that would pass the constitutionality test. Right. Which may mean that we may need to pick an area somewhere on US Route 1, somewhere away, as far away from people's houses as we can. There are some areas that meet that, but maybe we'll see if we have to cross that bridge. But fundamentally, if we have to cut back from the 1,000-foot, I think that we'd be doing the people of Guilford a favor if we ruled out the TS2 zone. So
I understand. There are 2 locations in industrial zones, as you may recall from our discussion 2 weeks ago, that actually are do have exposure to I-95 and also have access in one case to Route 1. The Pinchbeck property behind the Rose Gardens, the property, Pinchbeck's the owner of that property. It's industrially zoned, and it does appear to meet the 1,000-foot test, a location there for this type of facility. So without doing a full-blown study of their property and a hypothetical development plan, it certainly appears to me that there is there, and also on the other side of I-95, on the north side, in an industrial zone, there are 2 fairly reasonable potential sites for facilities of this kind in industrial zones.
So could we potentially say a bigger area of those industrial zones, as long as they're far and away from people's houses, that we could reduce the 1,000 to, say, 800 to 700 feet and still not encroach on anyone's home in those industrial areas?
Well, if you reduced it to 750 square feet, then it could be that there will be some places that it could be 750 feet to a residential zone. So that might expand the area in which these facilities could be located. I haven't really done that analysis, but it's quite likely that it would increase the opportunity within the industrial zones. I gather what your preference is to delete the TS. You mentioned the TS2. I don't know whether you also meant the TS zone. And the TS zone is the east side commercial strip, Route 1 East. TS2 is Route 1 West.
Give me a framework of where the TS zone is. What am I looking at there?
TS zone is basically everything east of Shoreline Plaza on Route 1. All the commercially zoned property on the front there. It's up where all the fast food restaurants are, the gas stations, auto repair, muffler, Dunkin' Donuts, various other uses, going all the way up up the hill, so to speak, on Route 1 east of Goose Lane. That's TS.
Is the dealership also TS?
Yes.
And the dealership is, if I remember right, there's no one living around that. There's nothing.
Now
the
test is not whether anyone lives there. The test is whether there's a residential zone.
Right. Right. I know. But I'm trying to fit in my mind, fit a spot in or several spots, and so we passed constitutionality.
That particular spot does not meet the 1,000-foot test. There's residential zoning on the north side of I-95, and then there's residential zoning basically or almost across the street on the south side of Route 1 there. Now, if you went to a 500-foot separating distance, then that might very well fit. Again, I haven't done that. I haven't done that analysis.
Also noticed in the copy that Chuck mentioned how Orange did it. They had the town engineer go out and physically measure.
That's a good idea.
That would
door to
that would
boundary.
Require require some lead time in order to make all that happen. But yes, that's another possibility. It's not that hard to measure. I mean, to do them especially with GIS and electronic means. It's not that hard to figure out what the distances are. Yeah. We have that capability. We don't have to have a surveyor go out there and do it. But that's, whether or not this meets the tests of allowing reasonable alternative locations is the first question that Chuck asks. Hours of operation is also one of the criteria that's included in the proposed draft, is that the hours of operation are limited 10 a.m. to 8 p.m. Monday through Saturday. In Chuck's opinion, the 8 p.m. closing time is unusually early. And then he references has some other discussion here in his comments. And he notes that 10 p.m. closings were upheld in a couple of circumstances. Prohibition of alcohol. Our proposed regulation prohibits the sale of alcohol at any adult-oriented facilities. Chuck thinks that that's valid. He quotes some references there that seem to suggest it might be. He asks that if there are any specific studies linking alcohol consumption and negative impacts of adult-oriented facilities, that would be helpful. don't know if that's explicitly included in any of the material that I submitted. It seems somewhat obvious that there would be.
I sent you an article about
Yeah.
a situation down on Long Island where a businessman
Right.
had a few too many drinks and his charge card ran up to $120,000 at one of these fine establishments.
Right.
So
I
so
didn't include that.
there is some
Of
support
course,
to that.
Yeah. Chuck discusses the separating distance issue in his comments. He's noted in a couple places 1,500 feet was used, 400 feet. In the case of Orange, I think 400 feet is the separating distance number. So he doesn't make any suggestion there other than to describe what some alternatives are. Floor area limitations. We proposed a 10,000 square foot maximum floor area. He asks if we have any specific indication in studies that larger stores have a greater adverse impact than smaller stores. I think that's an accepted rationale for retail stores in general. You know, that the bigger the store, the more potential it has for, you know, traffic and other adverse impacts. But I'm not aware of anything specific related to adult-oriented facilities, but, you know, I could do some more research. Chuck asks that we review the definition and recommends that we use one of the definition of what an adult-oriented facility is. And it's one of those things where, you know, everyone knows what an adult-oriented facility is, but, you know, to have a definition that's more explicit than the one we, or more careful or more detailed than the one we proposed is a suggestion he's making, and he gives us several examples of such definitions, and it's certainly easy enough to include that in our proposed amendment. Chuck makes some further kind of editorial comments about in the purpose section here, which again are helpful and quite easy to include in our proposed amendment. I'm sorry.
He keeps hammering away at finding more references, and I think
Yeah.
probably that's
Yes.
what you're talking about, right?
Right.
But did you tell him, did you show him all the references?
I didn't show him all the
So
references.
all he got was what we.
Yeah, we have quite a bit of
So
reference,
We do
but
have a lot already.
he's looking for, you know, on a couple of the explicit points that we make, you know, in terms of maximum store size, you know, is there any connection as provided in, you know, evidence or studies that a bigger adult-oriented facility is worse than a small one? You know, it would seem, you know, if a small one's bad, then a bigger one's got to be even worse, but
You
other than-
included other town policies
Yes,
for,
right.
who also probably address these issues, and they were pretty thick, so
Yes.
they might very well be.
It could be.
buried in there.
It could be. Again, I'm sorry, unfortunately, I only saw this today, so I haven't had a chance to really even talk to Chuck about it or go into any more detail. I think the gist of what he's saying is that we're on the right track. You know, in his opinion, we need to do a couple of things. You know, if we, you know, we'll take we'll take a chance with the 1,000 foot and see what happens.
Did he describe anywhere, I didn't see it here, but the consequences of one of these provisions being too onerous? For instance, if 10 o'clock is acceptable and maybe 9 o'clock is acceptable, but 8 o'clock is not, if that were ruled to be too early, what would be the result?
You mean if there was litigation and a judge were to say that's not okay?
Yeah.
I don't know that I can speculate exactly
Right.
what would happen.
But
Chances
you
are he
just
wouldn't throw out the
mentioned-
whole thing. He would say you can't have, you know, you can't be that limited in terms of hours of operation. You got to be more liberal and direct us to correct that. The thing about litigation regarding this, as I understand it, is it would be in federal court, because the appeal would likely to be, you know, on constitutional grounds. I have no experience with that whatsoever, so.
Okay.
I just got the underlying.
Excuse me.
He actually felt we were a little more restrictive and probably be a little more open and to not
Right.
involve this sort of situation down the road, but not by significant amounts of
Right.
footage and time frame.
Yeah, I think that's correct.
Good.
There was a letter, may I read it in?
Oh, please do.
Okay, it's dated September 2nd, 2014, to the Town of Guilford Planning and Zoning Commission meeting regarding the adult-oriented entertainment regulation. 1, industrial zone 1 and industrial zone 2 should be the only zones to allow this type of entertainment. As Mr. Kroll and Mr. Bauer discussed at the 8/2014 PZC meeting, these 2 zones have property available. Any other zones suggested would either not be available per the criteria or so limited to become unavailable per the criteria of draft regulation. Doesn't the allowing of any of other zones invite a lawsuit for obvious reasons? 2, the industrial zone are a logical fit when paired with the secondary effect doctrine. Shouldn't the town council be reviewing the secondary effects doctrine as it has been upheld by the Supreme Court pertaining to adult entertainment, and also to confirm that 1,000 feet separation has been upheld as perfectly reasonable and acceptable? 3, if liquor will not be allowed to be sold, will patrons be allowed to bring their own alcohol? Quote unquote. Thank you for your time. Deborah O'Neill, West End resident.
Great. I just wanted to make, let me just clarify one thing. I mentioned a property owner by name in my previous comments here, and the use of the term available suggests that, the property owner, that the property might actually be for sale or, otherwise available for development on this, for such a facility. I don't mean to imply that. I've had no conversations with the owner of these properties.
Right.
So whether they would be willing to sell the property to be developed for these purposes, I have no knowledge. So I just want to make that totally clear.
And we're perfectly clear on that. You have no knowledge of any of it.
And also, based off of the letter, I mean, we did discuss that at the last meeting,
Right.
how basically the TS2 zone realistically can't have any, adult entertainment facilities there, then why is it included?
Right.
So when we go back, if you find out that the TS2 zone is the best place to have something within 750 feet, or whatever the case may be, and it would be possible to have adult entertainment, then it would be something that you would include.
Right. Okay. And I don't think Ms. O'Neill, some of her comments clearly were addressed by Chuck in his memo. I don't think I don't think she had the opportunity to see this.
Yeah, that's true.
So what's our plan next? Are you going to review all this, put it together, come back in the next meeting? We'll take one last look and set a public hearing date?
No, we are in the public hearing now.
Continue.
So we'll continue. My suggestion is you continue it to the next meeting, by which time I'll have redrafted the regulation based on Chuck's comments here, and I'll go over it with him one more time to make sure everything is totally buttoned up, and then we'll present that at the next meeting, and then you can make a decision.
Okay. Well, that's very exciting. All right. Yes.
Comment?
Please.
Dawn Williams, 137 Jefferson Drive in Guilford. I'm thinking that maybe looking at 500 square feet as a setback would be much more reasonable, because from my online research, it seems like 500 is like the norm for these places. And they may ask for that, and they may be very successful in getting to 500 square feet, even if you tell them that it's 1,000 square feet. So is there any way that we can look at that as a median? In other words, the bare minimum.
I'm not sure, you don't mean square feet, you mean 500 feet.
I mean 500 feet.
Right.
From
Absolutely.
the property line, not the door.
Right, that would be the usual way of measuring this, from the property line, not from door to door. Yeah, I mean, you could go with any number the commission wants to. The 500 feet, especially if we allowed it in the TS and TS2 zones, would definitely open up more opportunities for this type of development.
No, I don't mean adding that to the amendment. I mean looking at that as an adverse. In other words, if it is added to the TS2, then you would take the TS2 out because it would be too close to property lines. In other words, we're going to say 1,000 square feet. If they come in and these businesses come in and say, no, we think 500 square feet is more reasonable. I mean 500 feet, sorry. is more reasonable, and they have been successful in fighting zoning
Right.
based on something like that, then I would prefer that the town do a study and say, and look at properties and these zones and say, if they came in and there were 500, we have to take TS2 out
Oh, I know what you
because
mean.
it's too close.
So you're saying remove TS2 as a possibility because somewhere down the line, someone may take the 1,000-foot and make it 500.
Yes.
Got it.
And there are instances where someone has successfully gotten that change from, say, something like 1,000 to something like 500.
There are.
Okay.
Do we know that these illustrative inserts that Chuck put in for a couple different towns here, I think one is Orange and one is Milford. Do we know whether, did Chuck say anything anywhere about whether these towns have had cases where they've had to go to court based on these setbacks and whether they won or lost?
I know Orange did.
They won.
Yeah.
So
So they lost it. Initially, they didn't allow it at all. They were forced, I don't know the exact history, so I shouldn't say. My understanding was they were forced to come up with a new regulation because they didn't allow it at all.
Okay.
This is what they ended up with. How that actually transpired, I don't know.
Because in some ways, I mean, it's a little more complex than what we have here. I mean, we could go with 1,000 feet, but in some ways, I really kind of like what Orange has done because they've done what we know already works, and that is, we say in Guilford you can't have a liquor store within 1,500 feet of a liquor store. Well, that's their first line. But then they reduce some of the linear footage. Well, they say 1,000 feet for preschool, and that obviously got that passed. The only thing that's different is that that within 400 feet of any zoning district which is zoned for residential use. So in that's a little bit more flexible.
Definitely.
But I would like to see, I mean, I don't want the town to spend a lot of time on this, but if you tested this, because if you could show where a radius of 1,500 feet from any possible zone and find out whether another building could be built that's within 400 feet, I think it'd be a pretty hard struggle to do that in Guilford.
Yeah, probably.
All set. That's all. Anything else? Anyone else? Last chance.
Well, you'll have a chance again if you continue the hearing.
Oh, well, of course we're going to continue. Goes without saying. Of course we're going to
Continue.
Yeah, does someone make a motion to continue this, please?
So moved. Second.
All in favor?
Aye.
Aye.
Carries. All right, so this is done.
Rich, do we want to set a date for that?
Yeah,
let's do the
whatever
next
the next
one.
meeting is, what's the,
The 19th or no? 17th.
17th?
September 17th, day of infamy. All right, let's move on to Hersher, Karen Rose.
That
Oh,
applicant
that's
is
tabled.
request continuation to the
we can't
1st
do
of
that.
October.
It's terrible. All right,
Do we have to move to second? We actually have to move the table.
To continue that hearing to October
okay, so
1st.
we got a second on that, all those in favor?
Aye.
All right. So, that's it for the public hearing stuff. We get a motion to approve the revised agenda.
So moved.
Second.
All those in favor? Aye. Okay, first up, Guilford Agricultural Society. What do you think?
I think we have a motion, and we probably ought to put that on one or
Yeah,
the other on the
why doesn't
table.
someone make the motion?
I'll read the motion.
You want to do the motion?
I will, hopefully. All right, proposed motion voted that the Guilford Planning and Zoning Commission approve a modification to its special permit approval of September 4, 2013 for the Guilford Agricultural Society at 111 Whitfield Street, map 40, lot 138, to allow a one-time use of the barn/pavilion for the duration of the fair, including setup and takedown time for the September 2014 season. This application is approved based upon a finding that it conforms with the zoning code. The special permit is effective on September 12th and upon filing with the town clerk.
Second.
The correction on the address there is Lovers Lane, not Leadfield Street.
All right.
Lovers Lane.
Lovers, 111 Lovers Lane, map 38.
I resecond.
All right, so what does anyone have to say about this?
Well, I'm going to vote for this. I'm in favor of doing this. I understand where the Guilford Fair is on this right now. I would like to say, though, that I really think that I hope that the Guilford Fair is in fact negotiating in good faith with the neighbors. And on the other hand, I really think it's incumbent on the neighbors to try to come together and narrow down what really are the key issues for them, and so that there aren't disparate pieces of information coming into a puzzle that never can be put together.
Right.
And so I hope we do that before we have next year's fair.
Right, and you know, right now they're just asking for this fair, and it's not like we're going to say, no, you're not going to have the fair. So yeah, obviously they are negotiating with the neighbors, and it's an uphill battle, I'm sure, because as Attorney Cronin said, there's a million different wants. Everyone wants something different, and I don't know how they're going to work it out, but work it out they must. Anyone else, Richard? Any
I
input?
just would hope that it gets worked out, that we don't sit with this problem again next year, 2 weeks before the fair. Is that what Tom said?
Yeah.
Frank?
Yeah, I think that, I don't think we're going to be in this situation next year. I think that there's going to be some type of agreement. I think there's a lot of work that goes in, and I don't think everybody realizes what it takes to maintain the fairgrounds, to run that, and to put on the events that this community has been partaking in long before I was a resident, and we were in here in 1977. Our family came here, so I really hope that we can come to an agreement. I second this. I will be voting in favor of it because I think the fair is a great event for the town.
I agree. Richard?
I just want to make a note of the date. Why don't we make it tomorrow, because instead of September 12th,
Right, because they got stuff they got to do. I agree. Josh?
Well, it can't be, the effective date can't be until the legal notice is filed in the newspaper. But I think, you know, the gist is that they can't use the pavilion, which is the fair itself. I mean, they can start the setup and everything. That's probably not really using the pavilion. At least that would be a reasonable interpretation, it seems to me.
Yep, I agree. Josh?
Well, I'm just happy Attorney Cronin's working with the neighbors. A little disappointed we didn't get to hear any feedback from the neighbors other than one letter. But I think that we're put in a tough situation here.
I think our path forward is pretty clear cut.
Yeah, in the letter that was against it, there was no reason, just said I'm against it.
Yep. So knows.
I know there's no way to assure this, but I guess, you know, I'd like some firmer assurances from the Agricultural Society that the Renaissance Fair and or any other for-profit activities aren't going to be taking place again in the future.
Yeah, and I'm sure after the, I'm sure we're all on the same page, and I know we are on the same page. Walter?
Well, this is a modification. I don't know, I think it's an interesting way to put it as a modification to the special permit approval. But I'm confused about why this isn't just going to keep happening. We thought that we considered this exactly a year ago, and we were in agreement that, you know, something really had to be adjusted, and the concerns of the Agricultural Society and the neighbors had to really be worked out more formally. And you know, these things are obviously, of course, difficult. I just I'm surprised that we're approving something on the same day that we're being asked to approve something on the same day that they want to start it. I'm surprised that the Agricultural Commission voted to violate zoning regulations for 2 weeks. And I'm surprised that immediately after they did that, they didn't start to move very, very quickly to to address the issues in the permit and aggressively address the concerns of the neighbors.
And that's all true, but we're 2 weeks out from the Guilford Fair.
That's exactly where we are. So, I mean, obviously, I assume that they know that we're going to approve this. And I'm trying to figure out which kinds of conditions are appropriate at this time and whether or not this motion contains all of them.
Well, what other conditions might you think are appropriate for this?
I mean, at this point, we have only 2 other events that are currently scheduled for this season. But I don't think it's appropriate to put those events or restrictions on other events into this approval. So I'm sort of at a loss.
Well, I think this approval kind of is about that pavilion. And we're saying it's okay to use it. But we're also talking about the permitted uses of the whole lot, which is for-profit institutions. And I think there are a couple of things, 2 different things there. This is solely for the use of this pavilion during the Guilford Fair. That's all we're saying yes to tonight.
And when we say yes to it, they can immediately start. It's pretty clear that they can immediately start moving, even if they've already started moving on setup. It's actually appropriate because they're not using it in an event per se.
Okay.
Right.
Okay. So, well, you know, one of the issues is, you know, and Tom said it, is the building safe? You know, so should we say that it should be subject to immediate inspection by the building department too?
It's been inspected.
They've reviewed it.
Oh, so it's done?
Yeah, that's,
Yes.
So it is safe?
yeah.
Yes.
Yeah, we're good.
Oh, so the question really is, can Guilford have the fair or not?
There's a motion on the
Yes.
table.
No, there's really, I mean,
Motion on the
there's
table. Yes to the fair.
yeah.
Yeah, let's call the question.
All right. So all those in favor of this motion?
Aye.
Aye.
I guess everybody understands, though, that the commission doesn't want to be dealing with this again next September.
Everyone understands that. And they're going to do their best to make sure that doesn't happen. But you know what? There's a good chance it could, because there's a lot of different neighbors that are going to want a lot of different things.
The neighbors have to get together and straighten it out, too. That's their,
Right.
that's their job.
And I guess one of the things is that we exist as the pressure relief valve for when the neighbors can't and the applicants can't. That's what we do.
Yep.
So we're going to do it. Congratulations. I'm going to come to the fair myself. Have a good time. All right, next up. What's next up here? Okay, so why don't you want to read? Okay, do we need to? Oh, we need to make a motion. Someone make a motion here.
Got it?
Close the public hearing?
Oh, yeah, close the public hearing. Sorry, yes.
Second.
Those in favor?
Mr. Chairman, I'd like to be recognized to make this motion.
Please, Walter.
Proposed motion. Voted that the Guilford Planning and Zoning Commission approve a site plan
Don't you
revision
want
for...
don't you want to have the applicant present this application first?
I thought they weren't here. I thought that was why we were...
Which one are we talking about here?
Goose Lane Storage? Are we? Oh, you're here. Sorry. We didn't know you were here.
I'm sure he would love to have you just approve it without...
Right, I know.
We don't need you. Please, join us.
Hidden under a chair as soon as we started talking.
All right, so you are the people with Goose Lane Storage. What do we know, Dan? What do we know about this?
Basically, we had a lot of contractors, businesses up and down. They need a spot when they leave the big spots because they've moved their equipment into the storage units. Basically trailers and some trucks are just looking on the back row where nobody can really see it. That's about it. I just have a couple of local contractors who are kind of stuck right now because they're out of the bigger facilities.
Reggie has a plan that she can help Mr. Carter elaborate on.
Is there, did I see a sailboat or a boat out?
Yeah, that's mine.
Oh, okay.
Well, my kids, when they were, I couldn't sail between two little ones.
Okay, Dan, I'm going to hold this and you point to it.
There you go.
What's going on?
Basically, our house is over here, and grandpa's old king cruise is over there. The 2 buildings are here. Goose Lane, out here, we're just looking at lining up some spots along the back row. Currently, I have my sailboats there, and I have a wood pile there. those are going away.
What's
The residents pretty much.
What's to the other side of the line there, Dan?
That was my, on Arthur's Field, it goes down to the pond. It basically goes 5 feet and then off.
Okay, so,
This is in an industrial I-2 zone, and it's surrounded by the industrial I-2 zone.
okay,
There is a residential district boundary line, and it's right in the middle of Goose Lane.
okay. That's on the back.
Center of the street.
That's right down here.
Okay, yeah, okay.
Okay, so the application is requesting outside storage on the property.
And it's already flat, it's already gravel.
Now, you can't have outside storage, if you read my memo, in the front, because it doesn't meet the residential district boundary line setback. You can't have it in the back because this is all industrial zone property here and here.
Can't have it in the back.
You can have it in the back, but you cannot have it in the front.
And the highlighted boxes are the areas in which the mini storage would be.
No
parking.
outdoor storage.
Yeah, the next door is probably these two buildings. That's just the parking.
Would this be visible from the road?
No.
No, it would be obstructed by the storage buildings in the back row.
After we go past Cradles to Crayons,
Wrong direction.
going north.
We ran into the big black glass building,
Mhm.
right next door. Okay. My house is a white cave next to it, and the storage units are next one, right next to Lucerne Gardens.
So no resident could see this in any direction, unless they were sitting on the other side of the
Not
Okay.
not in the back
Nobody
row.
could see the back row anywhere.
So some people seem to disagree with that statement. Like they're saying
There's
that.
windows across the street, but there's no way they could see into the back row.
So the concern, well, we'll ask them the concerns on that. So the single row is along the back heading towards the lake.
Yeah, the lake is right back there.
Thank you.
Right, remind the commission, this is a site plan revision. This is not a public hearing. You can, if you want, take comments from the public, but this is not a public hearing. If it meets the criteria of the regulation, then you do have to approve it.
Does it meet the criteria of the regulation?
The outdoor storage and the back it does. In the front, it cannot be.
So then we have no choice but to approve this.
According to state statutes.
Why is this not a public hearing?
Because this is an industrial zone, and this is a site plan revision. Site plan revisions are not public hearings.
He doesn't keep the site plan clean either.
When's the boat leaving?
You have both.
I think we should probably take comments from.
I don't think so. This is Marathon. This is called water of the
Okay,
law.
stop, please. Order in the room.
Right.
Our main question, whether the boat is in violation
It is,
or not, which.
it is.
Because we discussed that in the past, actually.
And the wood pile
was
is.
there. But there's a boat, no wood
And I've
pile.
spoken to Mr. Carter about that this morning.
Has he paid any of the
I
fines?
paid
Yes.
all of the fines.
$1,200.
We need,
But the boat's still
but
Boat's still there.
And the motor.
we're here discussing these units and how many units are there in total
On the back?
on the back?
Oh, it depends if it's you have a 20-foot trailer or a 15-foot trailer, but
The square footage of the row.
the building's 10 feet wide, so.
This is
10
a
feet
20
wide.
site plan, the 20 scale site plan. It looks to be about 10 foot wide and across the entire rear section of the area that's been approved for the storage plan, stopping at the edge of the last bay of storage units.
Now, is this storage of vehicles? Doesn't matter, it could be storage of anything.
That's outdoor storage.
So if there were unregistered motor vehicles,
They'd all be registered.
but we're approving this, it could potentially be
Anything.
anything. Is that true?
anything that's not toxic or hazardous.
You have the applicant in front of you, he's making a statement about what he will allow to be
Yeah,
stored.
just registered, because the way the state before, we had a bunch of vehicles that dumps there. And the way we were set up, I couldn't get paperwork on them forever, so I had to basically, you can't get rid of them legally because it's theft at that point. I had a couple boats that just showed up there, so I had to cut them up and got rid of them. And the cars, we had to have them paid to get towed, and even then it took a long time to get paperwork because I can't legally move a car if it's under 20 years old, even if it's dumped on your property. That was a long, expensive thing.
Well, I think the problem is, as I see that, I believe there were some violations on this going back a few months.
The violations had been removed except for the sailboat and the wood pile in the front.
Right.
And because they weren't removed in time, Mr. Carter paid $1,200 in fines.
Can I ask a question about sailboats?
Yeah,
That, his house is also on his property,
Yeah,
correct?
it's, my
That's
house is right
correct.
next to the
So
sailboat, actually.
are you saying that if I had a sailboat in a residential property, that I couldn't have that sailboat on my property?
no, that's not what I'm saying. What I'm saying is,
So what's the issue with the sailboat?
this is a site plan that's been approved for self-storage in enclosed buildings.
Okay.
There was no outdoor storage approved in the site plan. Now, because it is in an industrial zone, there is a 75-foot setback to a residential zone district boundary line where you cannot park or store anything
Okay, so
outside.
even though it's a residential, his residence, he couldn't do it anyway?
He could put it on in his backyard where his house is.
Okay.
It needs to be taken off of this property that's been approved for the self-storage units. It's complicated because he also has residence in the industrial zone.
Well, our choices are somewhat limited, however, we have tried to acknowledge when people wanted to let their voices be heard in every chance that we can. So, you know, I know you folks have a lot to say. I'd like to give you a few minutes each to just address us so that you know that we're here to hear you. You have heard that we have no choice basically but to approve this, but we certainly...
If it meets the regulations.
If it meets the regulations. So please, if you would like to be recognized and speak, this young lady first.
Excuse me. My name is Karen Tendler. I live at 14 Village Victoria Drive, which is right across the street. Our entryways are together. So we live off Goose Lane, which is a beautiful residential community. We take great pride in the upkeep of our community, including our lawn care, our landscaping, and our building maintenance. Across the entryway from our homes is what we would consider an ill-kept storage facility. There's rusted fences, there's weeds that are 3 and 4 foot high, and a myriad of what I would call boats and trucks in varying states of disrepair. They've been moved, but they've been there. I've been here 2 years. They've been there for a very long time, and it borderlines on what we would consider to be a junkyard. It's not the idyllic view that one would expect in Guilford, or for a community which contributes to the tax basis of Guilford, which for our community is roughly about $200,000. I'll go quickly. Over the years, there have been numerous complaints by the community and fines levied, and I thought I heard someone say this morning that there was even one from the Department of Health. There's no reason to believe that allowing further outdoor storage will result in anything different than what we've seen before. In Article 4, Section 273-73 of your zoning code, it requires that the site plan for each use be prepared with due consideration for coordination, and I'm just paraphrasing here, improvement of landscaping and other features that support the neighborhood, as well as the protection of various things, including property values. Furthermore, Section 273-75 addresses the fact that the use of land, buildings, and site development shall be of character as to harmonize with the neighborhood, to protect property values, and to preserve and enhance the appearance and beauty of this community. Based on these zoning guidelines put forth by this board, I beseech the board to ensure this application is not approved. It will create a situation that is not in harmony with the character of our neighborhood. It will undoubtedly impair the value of our property, and it will limit our right to quiet enjoyment. Thank you.
Thank you. I'm going to jump in real quick, and I'm going to let you speak, so don't worry. She mentioned or cited a couple of our own zoning code. In light of the ones that she's mentioned, we still have no choice. Is that correct?
Well, the commission has to decide, if you do decide to allow the storage in the back of the facility, which will be screened from the road by the self-storage units themselves. Will that affect views? Will that affect values on the neighborhood?
Well, that's in our opinion, though, right? So
Correct.
if in our opinion, storing those things in the back, not in plain view of the road, but as you're driving by, catching it at certain angles, if in our opinion that were true, that it would depress their property values, we could consider that.
Well, you would have to explain why it would.
That's easy. Okay, who else would like to speak?
I have some letters for you, and I have some pictures of the property. As the previous may I?
Oh,
give
please.
you-
You take the name for the record and address?
My name is Karen
Thank
Flatman.
you.
I live at 21 Village Victoria. Village Victoria, as we said, is across the street. We drive out our driveway and we see that storage facility. It is rusted. There are weeds growing. I don't even know how they can open the doors. I don't know if he's got customers using those storage facilities, because I don't know how you can even get into some of the units there. He has not been a good citizen. He is not, Reggie has been after him for a year and a half, trying to get him to remove things. Why now do we think that he will be a good citizen and put those trucks in the place that we say you can put them? I don't see that happening.
Thank you.
Thank you.
Appreciate you saying that. Just give me a second. I want to ask one more question while I'm moving on, because again, bear with me. Do we have a blight ordinance in the town of Guilford?
Yes, we do.
Would the blight ordinance affect this at all, or
It does, the blight ordinance does not cover commercial properties.
Yep.
The blight ordinance does not cover grass that is not cut.
Yep.
The blight ordinance covers objects that are on people's properties that are no longer able to be used for the purpose that they were intended, because there are missing parts or they're just parts of things.
Good. All right. Who else would like to be heard? Anyone?
Oh, yes, sir. Sue Shackford, I live at number 3 Village Victoria. Susan C. Shackford. I have a question. The height of the buildings now are they're not like low, but they're not high buildings. We don't want them to be high buildings, by the way. What's the height of the articles that he would intend to put back there? Would they still be visible to us?
No, like landscape trailers and pickup truck. I just have basically 3 contractors who are there, 2 young guys.
But what prevents you from expanding that? More boats or we start with light construction equipment that goes 3 or 4, 10 feet into the air and stuff like that. That's one of my concerns. But also, I also back up what my neighbor Karen has said. Going in and out of there, when I first moved in there 19 years ago, one of my comments was about how do we ever let a place like that come across the street from a nice entryway like this? And it was going to be a good neighbor and it was going to be kept nice. Just keeping the stuff grass trimmed. In the wintertime, the leaves are off the trees and we see everything for the whole entire winter. And as you know, leaves fall in October and they don't come back until April. So that's a lot of time looking at this ugly mess. Thank you.
Thank you.
Answer any of these or no?
Excuse me.
What I have to say is that I live at 7 Village Victoria. You know, we have storage units down at Woodfield Street that are beautiful, they're kept nice. Unfortunately, you should come and see ours, they're not. If they were anything maintained like that, we probably wouldn't be here tonight. The maintained of his units, I mean, the whole place looks like a dump over there. I'm sorry to say.
All right, Tom?
I was going to ask, what's the date on that site plan? When were those things put up?
it was the last, July 24th, 1986, revised to April 14th, 1987. And that was notes per the approval letter for the site plan.
Okay. Maybe the applicant would like to address some of the concerns.
You're up.
There's no rust on the buildings, they're brown, and the town did that so they would hide, so they wouldn't stick out. And if you read everything across here, I can't touch any of the vegetation, any of this, is inland wetlands, and that's where it says maintain vegetation. At one point, I had started cleaning up and I was told to stop. So, I can't touch any of those. I mean, there's stuff coming in front, I used to spray it, but my asthma, I can't spray this stuff, I have a company that's gonna come in to do it. But, the rest of it I can't touch because of how it was laid out. I think my site plan approval told me I couldn't.
That was an inland wetlands.
Yeah, the wetlands are over here. There's just
Where's your house, Danny?
It's right about here. And the driveway's literally right there.
Would you be adverse to having, would you be against anything that, for example, said that nothing can be put back there that is, say, more than, reaches a height of more than 6 feet?
Yeah, the truck would have to be higher.
Huh?
The big truck.
Yeah, pickup truck with boxes, probably 8 feet, but that's still way lower than the building. I mean, the door heights are 8 feet, so the peak of the roof is higher than that. And it'll only be registered. I don't want to deal with any more unregistered.
So for instance, a 10-foot height restriction would be no problem at all.
Yeah, that'd be easy.
Maybe what might make it easier for the neighbors is to truly guarantee that it can't be seen from the street, is maybe not come out to the very ends of the parking lot, but come into the middle and say the first 20 feet on either end can't be anything, so that when you're driving by, it absolutely won't be visible from the edges and below the horizon at the top of the garage. Is that something that I don't care about?
Yeah.
A little bit?
I'm only looking for 4 or 5 spots right now, and probably.
Right. So one of the problems, we were talking earlier about how we're sort of the referees when neighbors can't find their way, and this may be one of those situations. I want to acknowledge that you want to have a beautiful neighborhood, and acknowledge that you want to run your business, and so we've got to sort of figure out a way of accommodating both of you. And so, one of the things I think might work is maybe limiting to 10 feet anything stored back there so that it wouldn't be visible straight from the road, and nothing in the first 20 feet on either end, so it's not visible when you're going by. So that way they couldn't see that. I think one of their concerns, though, is not so much the vehicles or things parked in the back, but the overall upkeep of the building, and that's not a zoning issue. As much as I'd like to say, you have to keep it beautiful, I can't. That's not our business.
But you can request that the grounds be groomed.
Which this includes, though.
Now, as far as...
Right now, what you heard is that the grounds are not groomed.
Right now...
You've heard about overgrown grass and weeds.
Right now...
Is that accurate about the Inland Wetlands and Watercourses Act covering the...
But even if it does, there's a landscaping. There's a landscaping provision.
Or you can have his landscape contractor do that.
Right, so...
which I think would address...
Right, it would begin to address...
What we heard time and time again was the appearance.
Right, exactly.
I don't think they...
I don't disagree with you.
The grounds.
I don't disagree with you. To Tom's point, it's been there for...
87.
Yeah, so 17, 18 years. I don't know which came first, Village Victoria or this business. Simultaneous. So some of you may have moved in while it was already there, and it was sort of like a condition of moving, and you saw it. And he isn't a,
Facility, as an indoor facility, not an outdoor facility.
Right. So, we're in a tough spot.
Are there any other conditions that that they've focused on that have minimal cost to you that you particularly would value? For instance, a change in fencing.
I don't have fence.
Yeah.
So So what is this reference to rust?
I don't have a
Because
clue.
The doors are rusted.
the front, so the very front gate where it opens up is the rusted. I feel like I'm very familiar with this facility, and I
Can't pick it up.
So they're concerned with the gate, but how does the gate apply at all to this application?
It's
other than
it's
the
not a
fact that
zoning
it
issue.
goes in and out?
It's not a zoning issue.
Talking about the character of the facility and the harmony and the relationship to our neighborhood. And what this facility looks like, that's what the issue is with this.
Right.
With this.
But,
with-
right, and unfortunately, what we can regulate is the outside storage of items on that site plan. We can't say you have to keep it beautiful. I mean, he may want to do that, so you stop complaining to the town and having the town come in. He may want to do that, you know, if there's a host of violations, or if he's, you know, a couple feet off on one of the vehicles or whatever he has stored in the back. If the place were kept beautifully, maybe you wouldn't go, and he would be much easier to live in that facility.
Well, Mr. Chairman, I mean, I think what she's pointing out there is that our statutes do sort of touch upon keeping the area harmonious with the environment.
So can you...
Well, the only thing that I will sort of touch on there is those are sort of catch-all provisions, and it would be hard for us to make a legal conclusion on a catch-all like that when there is a valid application before us. I mean, that would be something that would be easily, I can't really use it, but I think that's something that could be overturned if we were to say, oh, it's not pretty enough today for, you know, for pursuant to our statutes. We're not giving really valid reasons. We don't have a list of real estate appraisals talking about it, you know.
These are your rules.
No, I understand that.
These are what the zoning committee has.
No, but what I'm saying is, and they also allow, we also can grant this special, the site plan that is requested. And what I'm getting at is that before us today is not a stack of real estate appraisals saying, okay, if you were to sell your house today in the condition that this storage facility is in, it's worth, you know, $500,000. If you were to sell your house when the storage facility is not here, it's worth $600,000. Or if you were to sell the house when your storage facility is here and it's worth $550,000 because it's cleaned up. We don't have that information before us. So we really are, we do have a reasonable application, and we have to make our decision based on what we have before us. Yes.
But you're skipping one part. It's the preservation and enhancement of the appearance and beauty of the community. I don't know how you quantify
Because
that.
it's subjective. And so,
Exactly.
I mean, the pictures that we received today, the pictures we received today, sure. I mean, go ahead.
What if you bring in, postpone the hearing for another time, open it up so that we can speak, and we'll bring a realtor in to
This
give
is not a
advice.
hearing. This is not a hearing.
This is a courtesy.
And we have to act on the information we have before us, and, you know, as our zoning enforcement officers have explained to us, you know, it's a valid application, and we're required to act on that valid application.
You can't put conditions.
We can put conditions, sure.
Okay, so...
replace the gate.
But I understand what you're saying, I just don't think that we can do that.
So it's 20 feet, and 20 feet, he has to go within 20 feet of each side. So how much space then is there for storage, outdoor storage?
I don't
How do you
know.
enforce that?
Well, Reggie would enforce it.
And I'd like to know when the vote is leaving.
Well, that's just.
Yeah, that's a
We
valid
can make that a condition in the approval.
I need to ask Reggie what I just asked her.
It is?
So that everybody's actually, so everyone can hear. Reggie.
Yeah.
I feel very strange repeating myself. What are examples of valid conditions relating to the gate and the landscaping in front of the building for this site plan application that seems to meet all of our regulations for outdoor storage in the back of
The commission has the option to refer this to the design review committee, to have them look at the appearance of the overall appearance of the facility from the street and let them make recommendations. And then based upon their recommendations, you can make an approval and make those conditions of approval. The gate is rusty, that can be painted. You have a design review committee, so you may use them.
Do we have the power to provisionally approve the storage of these items for a certain period of time while we refer this to design review so as not to?
It's better if you refer to design review.
Right.
Right now, he's under a cease and desist order to remove the boat and the wood. And because he's made an application, that stays the order. So nothing happens. He knows, I know, and the commission, the design review committee will be meeting the second Wednesday next week. We can go to them, they can look at it, make recommendations, and then we can bring this back to you at your meeting on the third Wednesday of September.
That seems wise. I mean, ultimately, as I'm sure the public has gleaned from our conversation, ultimately, the specific items that are being applied for are very likely to be approved. But they also don't seem to be the main focus of this group's concerns.
They are.
So
One and the same, they are.
they are the storage in the back of the trucks as well.
Yeah, the height and the how much and the.
Oh, absolutely.
The traffic and everything.
I think we put Mr. Carter on
3 in the
microscope
morning
as it
and
is
3
right
out
now.
in the
Pretty close.
evening, and then 3 out.
Yeah, because most of it is businesses, a lot of files, paperwork, and then people between houses. And then I have 4 contractors in that. And those are the only ones that.
In the meantime, the cease and desist is stayed because this application is still pending. So,
I just have another question in regard to the layout. What's the access for the road in the back? What's the access for the road in the back?
Through this storage
facility itself,
facility.
either on the right or the left-hand side?
Yes.
Like we did on the existing roads already?
When you drive in, there's a driveway that goes in front of the first building.
Yeah.
It makes a turn toward the back. And then there's a driveway that goes in between the 2 buildings. There are 2 buildings. And then as you continue on, you have no choice but to turn right. And that's the driveway for the people to put their items into the storage units in the back row.
So you're not adding a new entrance from the
Oh,
street?
no. Oh, no.
If I could make, I think Reggie's suggestion that you ask design review to see if they come up with some kind of ideas for how to better screen the property, maybe that's part of it.
I agree with that on principle. However, in particular, we're putting an onerous burden on
he's got a cease and desist that is stayed at this time while this goes forward. So there is a certain amount of value for him for this to be continuing for a little bit longer. While you're figuring out, because that cease and desist is stayed while he's going to design review, which is not, it's not so bad to have a cease and desist be stayed.
One of the things that everyone should be aware of, and we repeat it often enough amongst ourselves, is that design review cannot order anything. They can make suggestions to us, but they can only be advisory. They can't tell him he has to paint it, or he has to paint this color, he has to fix that gate, or he has to get rid of this rust. They could make some suggestions, but at the end it would come back here.
Colors are statutorily prohibited.
Right. You can't pick out colors for anybody. So anyway, this is a tough area because it's the residential against commercial.
One question of Mr. Carter. Are you aware that you have some people who use your facility who have actually been working out in the driveway with their tools, cutting wood?
Is that permitted?
No,
I have some interior wall architect,
there were 2
landscaper.
men. When you first pull in the
Yeah, he's
drive.
gone.
Oh, he's gone.
Yeah.
Okay.
He was one pound from getting it.
Okay.
I would ask
For both of us.
the, at this time, I think that I would ask, who made the motion? Josh?
No one made a motion.
No.
No motion?
No, so-
Okay, I'd like to be recognized to make a motion.
Please, go ahead.
I'd like to request, I voted that that this application be referred to the design review committee, that the stay in place on the cease and desist order, which it does no matter what. And that this be referred to design review, and that this application be continued to the second,
Third Wednesday of September.
to the third Wednesday of September, or the
That's
first
your next
meeting of
meeting.
October?
No.
For design review?
Your design review meets next week, you meet the week after.
Okay, to be, that this site plan application be continued 2 weeks to the third Wednesday in September.
Is that the motion?
That's the motion.
Do we have a second?
I'll second it, but I would like to just ask a question of the applicant.
Go ahead.
Is this going before the design review committee, would that be extremely onerous to you?
No, I mean, just looking at the statutes on it, I thought it would have just gone through because there's nothing against it, but so it shouldn't make any
Well,
difference.
here's my question, here's my thought on design review committee in regards to this. So we're going to send it to them. They're going to make some really good suggestions, as they usually do.
Yep.
Let's maybe put up a vinyl privacy fence. Let's maybe get all the weeds that are in front of the doors clean. Let's spruce up the property. Let's make it look nice. It doesn't take a 12-person committee to figure this out, what we want him to do. Whether he does it or not, that's up to him.
So
We
you're saying
can't.
That won't change anything.
That's not going to change anything. So we're just prolonging this for another 2 weeks. Now, he might not do a thing, or he might say, okay, you know what? I'm going to do all of this because I want the neighbors across the street to like me, and I just want to try to make everything. I mean, clearly one neighbor said that if it looked like another storage facility somewhere else in town that apparently is really beautiful, that they might not even be here. Maybe, maybe not. So my point is, are we just prolonging something for the sake of prolonging it? Like I said, put up a vinyl privacy
The
fence.
landscape architects and the other professionals on this might be extremely helpful. They might be unhelpful. But in the meantime, since the, as we mentioned a couple times, since the cease and desist order is stayed during this process, it won't really burden the applicant in the same way that some other kind of delay would. It's true that ultimately this site plan application seems to meet all of our requirements, and ultimately approval is very likely with some small number of conditions. However, what those conditions are could depend upon the advice that the design review committee gives us, and simultaneously what he decides to do to ameliorate these issues with the neighbors may be very well informed by the design review committee.
I can understand where you're coming from on all this, but in all references, Rich has spoken. Design review is strictly advisory. They don't have any teeth on this.
It's going to come back to
We
us.
have teeth.
We have the teeth, but I mean,
But even in
anything
this-
they arrive at is non-binding.
Right, and even in this, our teeth are kind of
Dull.
I mean, we put the man under the microscope enough right now.
You know, if they just call me, if they don't like the way it looks at the time, I'll go out and weed whack it and have it sprayed and bring more stone in. It's just that, you know, when you have a lawyer calling up, you know, profane even going off on the phone, it's not as, it's not the neighborly thing, but I mean, we've been there since forever. The whole property's never been sold. It's not like I'm going anywhere.
Will this 2-week holdup negatively impact your business?
What?
Would this 2-week holdup impact?
I've just got 2 young guys who are contractors who are on bad time and they have to get out of where they are. So their equipment's in there, but they have nowhere to put the trailer or the truck. And it's just 4 vehicles, I think, registered vehicles.
Is there any limit to can he store a propane truck on that property? if it's below 10 feet and it's within 20 feet? Can he
I
just
wouldn't
store
wanna
a
have
propane
that.
truck? What are the limits? Is it a gasoline truck? Is
I
it a
wouldn't want
chemical,
that
a
either.
non-chemical truck? And what are the
That's
limits?
industrial, it's an industrial zone.
Yeah.
So technically, right, no.
So,
But
yeah.
it abuts a residential zone. I mean, what are the ramifications of having a propane truck storage on a residential? But who's to say he's not going to do that?
But
You have kids
he
in the
would-
house.
It
Would you
doesn't
endanger them? I don't
be able
think
to
so.
do it. I mean, if it's zoned for, an industrial zone has, you can put a lot of different things in an industrial zone. And
Our contract says none of our tenants can have gasoline, any chemicals, paints, or flammables in their unit.
No flammable?
So that would mean no propane.
Yeah, I would not have a
Okay,
propane.
so that answers your question. All right, anything else?
I just think this referral has a good chance of.
Quick question, do we have any information as to whether or not the addition of outside storage has a positive or negative impact on residential neighbors?
On the
And
latest
is that,
That's what we should.
yeah?
I can't
I think it's kind of what Josh brought up, that we really don't have that.
We don't have facts and figures to go on.
that's why you can't.
So,
Nuisance factor tends to be
That's-
visibility related or traffic related.
And that's
They were
how-
mentioning lots more traffic. He was mentioning that it would be, sort of morning. So the motion's on the table.
yes, it is, and you have a second, and we've finished our discussion. So, we're going to vote, and the question is, are we going to approve this motion with the contingency that he has to go through design review?
Oh, no, right now.
No, he doesn't have to. There's no
the motion is to
approval.
Refer it to design review, and then the approval would be in 2 weeks.
Right. Yes.
Which I don't think it's going very far out on a limb to say that that approval is likely
Okay.
with a certain number of conditions.
Okay. All those in favor? I'm going to go with it, because you got 2 weeks. So that's 1, 2, 3, 4. Gentlemen, opposed? 3. So this motion carried. We're going to consult with design review, please, and we'll see you in 2 weeks. And I'll
There
come
will
up
be a
with-
height provision on it?
I beg your pardon?
There will be a height.
That'll be determined in 2 weeks.
In 2 weeks, okay.
Thank you for your.
Thank you for all.
Thank you for coming. Remember, we're always open, you're always welcome to join in this process. All right, thank you. All right. Just bringing your brains out.
Spent an entire hour today
See,
looking for
the problem with that is we shouldn't be
$300,000
prohibiting businesses.
and that hurt less than.
We shouldn't be negatively impacting businesses.
You are, that's just it.
We just did.
But he told me that it wouldn't affect his business. I asked him, I said, is this going to affect your
Katie
business?
pointed
And he
out we
said,
didn't
no.
I told you don't ask.
actually move to receive that
He didn't know that.
application. So can you move to receive it?
Anyone make a motion to receive it?
Move to receive.
Second,
Second.
Call the question.
Mr. Chairman, somebody'd like to talk to you.
I just want to say like you guys doing a great job.
See you later.
thank you, sir.
See you Friday. See you Friday.
It's much more needed to say most likely negatively impacts.
Thank you for coming. All right, we have a second. All those in favor of receiving the application? Aye, thank you. Okay, good. All right.
So if I understand this one, and he would just ask the question.
Okay. We all set? Back to reality. Special permits to be received. DDR Guilford, 1919 Boston Post Road, map 79, lot 34, 35, 36A, zone SCW. Special permit, site plan for restaurant drive-through service, section 273-204A5, and outdoor seating, 273-75Q1A, receiving said public hearing date.
So moved.
Second.
He hasn't said the date yet.
9/17/14.
I don't know about this. We're in the middle of working with Route 1 West.
It's not in their zone.
Yes, but the traffic will be going through their zone. And, you know, we're talking with them about possible.
This was already approved.
We're gonna hold up everything because you're in the process of Route 1. This is DDR. This has been approved already.
That's correct. They already got approval, and they've already represented to us that they will break ground in fall of 2015.
14.
Fall
They
of
finished in 15.
Yes.
They're already
finished.
working
They
on
broke
the
ground.
septic system.
Yeah, so
This is
based on the current approvals.
now there's something else.
I
So
mean, they've already promised that in September, October of next year, we're going to be in business.
So anyway, I was going to see if anyone wanted to run this past Route 1 West and see if they have any feelings on it one way or another.
Absolutely not.
Let them review it. And I guess,
Yeah. Well, George, what is the time frame on the public hearing date for the special permit under these circumstances?
I'm not sure what you mean by what is the time frame. You have to hold a public hearing within 35 days of receipt of the application, and you have 65 days within which you can conduct the public hearing. Then you have to make a decision within 35 days of concluding the public hearing. And any one of those periods that can be extended by that same amount, subject to the agreement of the applicant. I think those are the numbers. 35, you have a public hearing within 35 days of receipt, and you have to conclude the public hearing within 65 days of opening, and then you have to make a decision within 35 days after the conclusion of the public hearing, or else it's automatically approved. So that's the law.
And you have applications submitted that you have to.
Can I say something?
You do have an application, yes. You don't have the choice to not to receive an application. You have to, if an application is submitted, you have to receive it.
That's right.
If it's one that requires a public hearing, like as does this application, then you have to set a public hearing date. And it has to be within that 35-day window.
I say, this applicant has been through history of permits and hearings and everything else, so why don't we just accept the public hearing date of 9/17/14?
So what, I'm not sure, I
mean,
understand
let's not-
what is the question? Whether to have it on 9/17 or some other date?
Why don't we have it on 9/17? We've dragged this applicant through the process for years.
We usually determine these dates sort of administratively based on what we think, what the agenda is going to be and how much, if something's going to be really crowded and require a lot of time, then, we kind of balance that out. I think Katie has worked with the applicant to establish that this is a good time for them. It looks like it fits into our agenda, and therefore that's why we suggested the 9/17.
I agree.
well, I'll tell you why I'm asking. I try to take to heart everything that goes on in this room. I don't always agree with what people say, but I do try to listen and learn from it. And one of the things that happened in our last meeting was Commissioner Bauer was talking about how he really needed to consider and really look into the motion and read through it a few times and understand it. And it made me realize that sometimes we just push things through. We just say, these guys have been through this so many times. And yet I know from working with Route 1 West people that they are looking at very specific things in that side which are contingent on traffic growing. And each time we add something to it, there will be more traffic. And I just want to run it past them in light of what Commissioner Bauer said, which is to carefully consider and think about each and every aspect of something we do. I probably would not have thought about this had not Commissioner Bauer in our last meeting said that he wanted to review something a couple of times to make sure he clearly understood and thought clearly about it.
So you want to have a Route 1 West committee have an
Just take a
opportunity
look
to have
at
a
it.
meeting prior to the
When is the
public
next
hearing?
Route 1 West committee meeting?
I don't know.
September 16th.
But what would they be actually looking at? It's an approved use, and they're applying for the permit. So what are they looking at? Are they going to say, well, we don't want to drive through now?
So
The,
we have
the
deal with
applicant
pharmacists
states,
to it.
the applicant states on their application there'll be no increase in traffic.
No, I understand. I'm just trying to figure out why we're asked to set a public hearing, and there's one that's proposed.
Correct.
Why are we going to give that, where there's an approved use, but they had to come back to us for a public hearing? Why are we going to send it to another committee to look at? It just seems like we're delaying something, and I don't understand why.
Do you think Do you think that we should accept on its face the representation that drive-through restaurant does not increase traffic?
I think that they're going to come and make a presentation. They're going to show us that the state approved it, that they meet the minimum of car stacking from window to menu board to street. They're going to have traffic study. I mean, they're going to come in and show us the actual scientific stuff.
And we've approved drive-throughs based
on that
those
location.
Kinds of, we've approved drive-throughs, actual drive-through site plan applications in the past, where we saw that, where we were presented with all of those things, and some of those have resulted in a surprising number of accidents and congestion and difficulty, right?
No.
None of them have?
No.
Okay. I think that the next Route 1 West committee is on the 16th. So I think it may be appropriate. I mean, I don't know if they can turn a referral around in a single day. So I think the question with a 35-day time frame is really whether it's the 17th or the first meeting in October.
What do you mean?
With a 35-day time frame.
Isn't the Route 1 West Committee able to sort of discuss any of these, any issue that is, before them?
Because their next meeting is on the 16th.
So why can't they discuss on the 16th and come in and talk to us on the 17th?
Keep in mind that you don't have to conclude the public hearing on the 17th.
Correct.
You can continue it, for up to 65 days. And in theory, 130 days if the applicant agrees, which most cases they will, because the last thing they want you to do is deny it based on the fact that you're looking for some information that you couldn't get or something. So there's a lot of flexibility with regard to continuing the public hearing, much more so than with scheduling a public hearing. I mean, even if an application is submitted, you don't have the option to not receive the application. You can receive it and deny it. If it's an application that requires a public hearing, you can't deny it until you actually have the public hearing. So you have to set a public hearing date.
Is what you're also saying is we can have a public hearing on this on the 17th and then halfway through the public hearing say, hold on, maybe Route 1 West should have a look at this because they haven't looked into this. Yeah. And that might be the better course to do something like this?
You can do that. That's definitely an option.
Okay.
Yes. Or if somebody has some question that nobody has the answer to on that date, that's the obvious thing to do is to continue it to the next.
Is Route 1 West advisory?
Yes. Yes, it is.
Yep. Mr. Copps.
Couple of things. First of all, the initial application for from DDR included a restaurant up there. That's not new. The drive-up portion of it is, but this commission last December approved that as an approved, it may be by special permit, but it isn't, but this commission right here said, okay, to a drive-up up there. All right. So it's being a little disingenuous to say now, gee, now we have another committee, so they have to decide it. The second thing is, George made a good point that you don't necessarily have to render your verdict on the 17th. It still gives the Route 1 West study group a chance to talk about it on the 16th at their meeting. And the third thing is that when Route 1 West, the first group, I think, was looking at Route 1 West starting just past the rock pile, not including the rock pile. So now you're adding another layer to it. And I have to go back to what Dick Wallace said, and that is that the DDR has been put through hurdles. The rules keep getting changed on them. They keep changing some things, and the rules keep getting changed on them, and I don't think that's the right thing to do.
Is this an example where the rules are getting changed, or where they've decided to change something after an approval?
No, I don't think it's something after the approval. They're coming back to me saying now, this isn't approved use. We want to have drive up at it. Whether they were planning that or not, we don't know because it never got that far.
This was not
the other thing as far as traffic, there's going to be a traffic light there. It's not like where you have out in front of
shop McDonald's where there's no traffic light.
Well, that goes to the merits that we would be discussing in the public hearing. Yeah.
Well, I think that I agree with Richard Voss. With Tom, they have been through a lot. However, if this is change, we wouldn't be talking about this unless we have a site plan with a restaurant with a drive-through. I know what we were talking about in that meeting was perhaps a Dunkin' Donuts or something with a drive-through, not a restaurant with a drive-through. And I can't believe that everyone who comes out of that shopping center after having gone through this restaurant with the drive-through is going to go immediately towards the 95. I think there will be increased traffic going towards the West End. And I think that out of respect to a committee that's looking at doing work on that, probably want to consider that. However, we certainly maybe can open a public hearing on the 17th. I don't know that we'll be able to render a decision without some input from Route 1 West. And they might have some questions too, which might be best answered in their own little meeting. But we'll make that decision.
Excuse me for interrupting, but have they been invited to talk to Route 1 West?
This site.
No, that would be tonight that we would do that.
Somebody let them know that, make the proposal there, like they had done to other advisory committees like Economic Development 10 years ago.
Sure.
Does each piece going in there have to be for special permit?
No, as Steve mentioned, the Table 5 committee, in their wisdom, when they reviewed the issue of drive-through restaurants, which are not permitted in any zones today, or they were not, they recommended that drive-through be allowed in this zone by special permit. So the applicant here, DDR's, taking advantage of, or proposing to take advantage of that opportunity by requesting a special permit for drive-through. Also, because this location is within the minimum distance of a residential zone, outside seating also requires a special permit. So there are really two special permit applications here. The outside seating isn't anything new. That's true of all restaurants. If they're within, I've forgotten what the number is, but a certain distance of a residential zone, then it's a special permit. So there's two special permit activities: the drive-through service associated with the restaurant and the outdoor seating.
Okay. Well, good. Then
I'm still a little bit worried about the turnaround time from the 16th to the 17th. It's appropriate to have a public hearing date on either September 17th or October 1. That's your motion, I think.
Well, I get to do this.
I have a first and second from Frank and Tom.
When was that recognized?
I didn't recognize anyone. They said they wanted to make motions, but I didn't call for a motion. Did I miss it? If I did, then I'm wrong.
I don't recognize anyone when they make a motion.
You were
First
reading.
and second, and then keep going.
You were
Right.
reading from the agenda.
All right, so, this isn't worth having war over. I have no problem opening the hearing on the 17th. I think that we should receive that, but I will reserve the right to really look into it. And again, I really want to take into consideration the advice from other commissioners that I received last week, which was to really fully understand before I move forward with anything, because I think that he had a valid point when he said that. And I'm truly going to embrace that. So, okay, 17th it is. The other...
You didn't vote on it.
No,
We
we
have to
didn't. Anyone second that?
Yeah, we have a second.
All right,
from
so...
Frank, right?
Yep, we do. So, all those in favor?
Aye.
Great. Klaus Bog, 260 Hart Road, Mach 106, Lot 14-1A, Zone R8, Special R8. Special permit accessory structure of 750 square feet, Section 273-94, receiving some public hearing, date 10/1. Any input from anybody on this?
Will we receive it?
Second.
All those in, discussion, all those in favor?
Aye.
Great. Site plan, zoning amendments.
Number one, amend section 273-251, add M, setback, receive and set public hearing date for October 15th, 2014, and I'd like to put that in the form of a motion.
Second.
Let's discuss this. What is this?
These are, we talked about this once before, in the town center south overlay zone.
Yes.
We neglected to deal specifically with the issue of setback requirements for new uses that are proposed, special permit uses that are proposed in industrial zones. And it's come up, this came up in our preliminary reviews of the proposed 66 High Street plans, which will be eventually a special permit application that'll come before you for residential development in an industrial zone. And it became clear to us that we don't specify what the setback requirements are within that overlay zone. So what this is designed to do is set those setback requirements.
And we're setting a public hearing on whether or not those are good.
Right, yes. Well, I'll explain it all in detail then, and you'll take testimony on whether it's a good idea or not.
Great.
But it was to some extent an oversight in the original drafting of the overlay zone district regulations.
Okay. So Walter, you've moved that. Do we have a second?
I did.
I think you did, okay. So all those in favor?
Aye.
And number 2, amend section 273-206, sign requirements for SCW zone. Receive and set public hearing date for November 5, 2014.
I have a question on this.
Design review?
Is this
not a
related
design
to
review
the-
issue first?
Is this related to DDR project?
They already went.
This is DDR. DDR is making this proposal. They've already been before design review. The sign regulations in that zone now were originally proposed by DDR with the type of shopping center that was originally approved, the so-called lifestyle type shopping center, which has different kinds of sign requirements. The new shopping center, which is not a lifestyle shopping center, they believe should have different types of sign regulations, and that's what they're proposing. So this is an application of DDR's to amend the zoning code with respect to the SCW zone to create new sign requirements, new sign zoning requirements pursuant to the new model of the shopping center. And they have reviewed and discussed this with design review already.
Design review's already seen it
Yes.
as of now.
Right.
Okay.
Yes.
All right, amend to September 17th.
Second.
Favor? Does any other discussion? Not in favor?
Aye.
Aye. Okay.
DRC's already seen.
Correspondence, the moratorium on hazardous resources. Share some thoughts. I've given it a lot of thought, looking in my heart, figuring out which way to go. And right now, we don't have any real applications to speak of. I don't know that a moratorium would be a strong move at this point. Anyone have other thoughts on that?
I agree with you.
I would agree with you. Was big in favor of it to start with.
So?
I'm not for a moratorium. I'm going to recuse myself from the question.
That's right.
Oh, that's right, sorry.
I'd need more time to look at the matter.
All right, so, Walter?
I was going over our minutes from last time, and Ray was discussing that this affects a single property, or that it would seem to affect a single property at this point unless someone were to apply for an additional zone change for another property. And in light of the circumstances, I think that a moratorium during our hazardous materials review has not yet shown itself to be necessary.
Okay, good. All right, so why don't we just put this on hold for a while? I don't know, should we take a vote on that, or? just put it on hold for a
Just a
while.
vote.
Table. Yeah, why don't we table it? So let's have a vote. Someone make a motion to table.
Move to table.
Second. In favor?
Aye.
Aye.
Great, that's good news. Okay, other, we've got some great news. Absolutely outstanding news. Phil Johnson wants to join the planning committee. Isn't that exciting? Phil, thank you so much, it's great. I think Steve is going to love having you here, you'll work great together. Absolutely wonderful. Best news we've had in quite some time. Okay, Route 1 West mission statement. Now, you know, we talked about this last meeting. You know, the folks on Route 1 West really worked hard to come together with that. I brought it here, I read it. I didn't recognize that it might be controversial, but apparently it was. So anyway, I'd like to try and nail that down tonight, what the Route 1 West mission statement is.
I don't think anyone was speaking out specifically against it. I think Ray was just looking to review it a little bit longer.
So we presented one at the meeting, and should we make a motion to make that the statement, or like, what do we do here?
Move to approve the statement as delivered to us from the Route 1 West Commission.
All right, so are you making that motion?
I'd like to put that in the form of a motion.
Anyone seconding that?
Second.
All those in favor? Aye. That's great. Second best thing. I cannot believe this. We have a tremendous amount of bills that we have to approve for payment here. I don't know how it got this high. We have $166.61 in bills that we have to approve.
Move they be approved. Shoreline publication.
Second.
Any other discussion? This is killing me. All right, I'm going to do it only because I want to be responsible, but all those in favor?
Aye.
All right. All right, approval of minutes, 8:20 regular meeting. Has everyone had an opportunity to review these minutes? Do they look accurate?
Yes.
Okay, so can I get a motion to approve them?
So moved.
So moved.
All those in favor?
Aye.
That's great news. Can I get a motion to adjourn?
So moved. Second.
All those in favor?
Aye.
Good night, everybody.